Morning, it's Attorney Josh LeRoy. I'm at the Palm Beach County Courthouse in West Palm Beach. I'm going to make a video today talking about options after a person gets arrested. As criminal defense attorneys, we assume that clients understand what their rights are and know what options they have available following an arrest. The reality is that most people don't. So, for most cases, the reality is that there are really only three options as far as outcomes for a case. One is a trial. That's the traditional jury trial setting that you see on TV and movies, where a group of people decide if a person is guilty or not. The state attorney has the burden of proof, a very high standard of proof beyond a reasonable doubt, and they have to prove that the person committed the charged crime. Another option is a plea agreement, a plea bargain. Most plea agreements take place with the state attorney's office, and that's how most cases resolve themselves. Most cases resolve via plea negotiations and result in an agreed upon sentence by the parties. After the parties agree on the terms of that plea agreement, the court has to ratify it and accept it. Vast majority of cases in the criminal courtroom are resolved via plea agreement during plea negotiations. Now, plea negotiations can have a variety of possible outcomes or a variety of possible conditions. It could involve a jail sentence. It could involve just paying fines and court costs. It could involve probation, or a plea agreement could even include a diversionary offer. Something in Palm Beach County we call deferred prosecution agreements, or PTI agreements. PTIs are pretrial interventions, and deferred prosecutions are a little less formal, but essentially the same result. PTIs and deferred prosecutions result in dismissal of charges. The last option, generally speaking, for a person charged with a crime, is a plea to the court. And in that circumstances, the defendant chooses to admit the charge, admit guilt, or plead no contest, and have a judge decide what the appropriate sentence is. The judge gets to decide then what happens to the person. The judge would have the ability to sentence the person to a variety of things, including, like we just talked about, court costs, fines, court costs, probation, or incarceration. A judge in Florida has very, very limited authority to dismiss a case. In fact, it's very rare. There's a very specialized motion that has to be filed. It's called a C4 motion to dismiss, based on 3.190C4, but it doesn't happen often. So the reality is that most persons, 99.9%, have those three options on the table as far as resolutions are concerned, have those three options on the table as far as what can happen with the case. Now, the state attorney can always dismiss a case. The state attorney always has the discretion to do that, but that's something in their control. Obviously, what we want to do as a defense lawyer is encourage or enforce or make the state attorney want to drop the charges, make the state attorney want to walk away from their case. This has been Josh LeRoy, signing off.